So Marcus thought he was just walking to his car. He had stopped at a convenience store in San Jose and was heading home. Being detained by police in California was the last thing on his mind. Then two officers stepped out. "You're being detained," one of them said, and Marcus had no idea what this meant, but he started explaining himself and said everything he was not supposed to say. By the time it was over, he was in handcuffs. Here's what most people get wrong about being detained. Your right to stay silent kicks in the moment that detention begins, not after you're formally arrested. Right now, on the sidewalk, in the parking lot, wherever you're standing, most people talk because they think rights only apply once the handcuffs come out. But that assumption is exactly what prosecutors count on. I'm going to give you the exact phrase to say. I want to walk you through how a routine stop can escalate into a full arrest before you even realize what just happened. Detained versus arrested. So let's start there because the word detained creates real confusion. Under California law, a detention is a temporary investigative stop. It's temporary. Officers need reasonable suspicion to detain you, meaning specific and articulable fact that suggests you may be connected to some sort of a criminal activity. That is a much lower bar than probable cause, which is what they need to actually place you under arrest. An arrest takes you into custody. When you're arrested, you are not free to leave. A detention holds you in place long enough for the officers to confirm or dispel their suspicion about you having committed a crime or you having some sort of evidence of a crime on your person or in your property. Two different legal situations with two different sets of rules attached. Now, Marcus, in the scenario that I just described, is based on a number of situations I have handled, with details of course changed, but the outcome, talking too much and ending up in handcuffs, is something I have seen repeatedly many times in Santa Clara County and other counties in California. Now, when he heard "you're being detained," he should have stopped talking immediately. Instead, he kept explaining himself, kept answering questions, kept giving information that the officers used to build a case, and California has no stop and identify law. During a pedestrian detention, you are not legally required to provide your name. You're not obligated to explain where you were going, who you were with, or what you were doing. One thing to keep separate: if you're actually driving a vehicle, you do have to show your license when an officer asks you for it, because that is a condition of driving. But standing on a sidewalk during a detention, giving your name is your choice, not a legal requirement. The words that matter. During contact with law enforcement, you're allowed to say, "Am I free to go?" That question forces the officer to make a declaration. If you're free to go, you walk away calmly. If you're not free to go, now you know you're being detained, and you follow with the second phrase, which is, "I'm invoking my right to remain silent." Then stop talking. Those are not magic words that make police back down. They're legal triggers that lock in your rights on the record. Once you invoke your right to silence, continued questioning without an attorney present creates a serious problem for the prosecution at trial. I have handled cases where a client said 10 words during a detention, during that temporary stop, and those 10 words became the backbone of the prosecution's case against my client. I've handled other cases where a client said almost nothing, and we had significantly more room to fight. The difference almost always comes down to what happened in the first couple minutes. And one note for anyone in the Bay Area who is not a U.S. citizen: H-1B visa holders, F-1 students, green card holders. This matters even more for you because statements made during a police stop can surface in immigration proceedings even when no criminal charges are filed against you. Give your name, invoke your right to remain silent, and contact an attorney before you say anything else. So what police can and cannot do? Let's talk about that. During a detention, officers can ask you questions. You do not have to answer most of them. They can conduct a pat down for weapons, but only if they have specific articulable reasons to believe you might be armed and dangerous. This is for their safety. This is called a Terry frisk, and it is limited to the outer surface of your clothing. Here's what they cannot do. They cannot search your phone. Under the case of Riley versus California and the California Electronic Communications Privacy Act, your phone requires a warrant. They cannot search your car without your consent. A warrant or a recognized exception tied to the specific fact of that stop or that incident. If they ask for consent to search, the answer could be no. Avoid answering questions about your destination, your passengers, what you were doing before the stop, or anything that sounds like casual conversation. Officers are trained to gather information and build rapport at the same time. The conversation you think is just passing time is often the most important part of the stop from an evidentiary standpoint, and anything you say can actually be used against you. When I was a prosecutor, I watched stop after stop where the defendant handed over the piece of information that turned a thin case into a conviction. Most of those people believed they were simply being cooperative or they wanted to seem friendly. Now let's talk about how long they can hold you. So California law does not set a specific time limit for detentions. What courts requires is that the stop lasts no longer than reasonably necessary to confirm or dispel the suspicion that justified the stop in the first place. So courts have generally found that detentions of 15 to 20 minutes to be within the bounds. Longer detentions require specific justification that's tied to the circumstances of the stop. If an officer is waiting for a K-9 unit, for example, or running the information through a database, that time counts towards the total. But there's one thing that's worth knowing. Courts do not accept an officer's subjective sense of urgency as justification for extending a stop. If other resources were available and the officer chose to wait anyway, that choice gets examined. Length does matter. What happened during that time matters. When I review a case involving extended or prolonged detention, the first thing I look at is whether every minute of that stop was actually justified, necessary by the facts on the ground. If you think the stop has gone unreasonably long, you can say calmly, I believe this detention has gone on longer than necessary. Am I free to go? Do not argue. Do not get physical. Do not escalate. Do not fight the police. But note the time because the detail can matter significantly in court down the line after your case is filed. When detention becomes arrest, let's talk about that. A detention becomes an arrest when officers develop probable cause during the stop. That can happen several ways. If you consent to a search and they find something, you have given them what they need. If you make statements connecting yourself to criminal activity, those statements can establish probable cause. If an officer observes something during the lawful pat-down that goes beyond what they were looking for, certain exceptions allow them to act on that observation. So running is almost always a mistake. Courts have found that flight from lawful detention can itself give officers reasons to act on and even support an arrest. If you believe the detention is unlawful, the place to challenge that is in a courtroom, not on the street. And once you're under arrest, your rights shift significantly. I covered what Miranda rights actually require in California in a separate video, including what officers must tell you and what they're not legally required to say. That one is worth watching if you have not seen it yet. And one more thing before you go. Police are legally allowed to lie to you during an interrogation in California. That is not a rumor, and it is not limited to what you see on TV. I am covering exactly what that means and what the most common tactics look like and what you can do to protect yourself in an upcoming video. What you know going in about the moment could change how your case unfolds. The Miranda rights video is a good next step after this one. It picks up where this video leaves off on what happens after a detention turns into an arrest. And if you're facing a situation in San Jose or anywhere in the Bay Area, if you want to speak with an attorney, you can call Night Law at 408-877-6177 and drop your county in the comments because I try to read all these comments and I'm interested whether what happened during the stop that involved you or a loved one or a friend was actually legal.